there has been a narrative which is built in media, social media, YouTube channel. If we total up the number, my lord, it would be running into few weeks. But when they argued before your lordship, my lord, every counsel took 5 minutes, 7 minutes, 10 minutes. And our effort will be to show why. We will have to show the facts. Because narrative was different and facts are different.
Yes.
He goes on to say that Muslims of the country must unite.
After considering the submission of the learned counsel for the accused person, that they will make consensus
Yes.
among them.
Kapil Sibal wanted to go, so he was.
He's not like this.
Take more than few minutes. My learned friend would be leading us.
No.
I just want, my lord, some of the highlights to be shown to your lordship. My lord, very surprisingly, there has been a narrative which is built in media, social media, YouTube channel. If we total up the number, my lord, it would be running into few weeks. But when they argued before your lordship, my lord, every counsel took 5 minutes, 7 minutes, 10 minutes. And our effort will be to show why. We will have to show the facts. Because narrative was different and facts are different.
Yes.
Lord, your lordships have been told two key words. First,
Have you prepared any synopsis or anything?
no, I'll not prepared. We'll definitely will not fight.
No. If it is so that we will make our notes in that itself. That is why.
But your lordships were being told that there was a protest and it resulted into communal riots. Correct, my lords? My lords have seen several communal riot cases, my lord, where because of some incident, some event which happens, and my lord, spontaneous reaction takes place, which results into a communal clash and my lord, results into a rioting situation. Lord, first of all, I would like, my lord, that myth to be bursted before your lordships. First, this was not, my lord, a spontaneous riot, but a well-designed, well-crafted, well-orchestrated, pre-planned, choreographed riots, and that, my lord, will emerge from the evidence collected. Some group clash and there were violence, some animal is killed and violence, one community attacks other and violence. This was not a spontaneous act of violence. It was an attack on the sovereignty of the nation. And I say this with a sense of responsibility because
Yes.
speech after speech, WhatsApp after WhatsApp, statement after statement, there is a clear and discernible attempt to divide the society on communal lines. It was not, my lord, a mere agitation against one particular act of the government. And, my lord, for example, my lord, Sharjeel Imam, I'll just give 2 or 3 illustrations. What he says. He says that it is my heartful wish that there is a chakka jam not just in Delhi, but for every city where Muslims reside. He doesn't say there needs to be a chakka jam.
Who says so?
Sharjeel Imam, a supposedly intellectual, my lord, for whom, my lord, much narrative is built outside the court and no arguments were advanced inside the court. Then he says, my lord, are Muslims that incapacitated that they cannot close down UP? despite Muslim being 30% of the population, why are the cities able to run? He was not talking of only Delhi. The riots were not Delhi centric according to their plan. It could not, my lord, spread elsewhere is because of the security agencies. He goes on to say that Muslims of the country must unite and separate the entire northwest from the country. Which, my lord, my learned senior friend, my lord, will read, my lord, those statements. I'm just, my lord, trying to point out that it is not a spontaneous riot, which needs to be, my lord, taken very, very seriously. It's an attack on the sovereignty of the nation when you divide the countrymen in communal lines. Then he says, my lord, that the real goal is to ensure that Delhi does not get milk or water. This is not a protest as sought to be made out.
Yes.
Lord, then he says, he challenges the authority of the court. I'm not saying this as an argument of prejudice. Court ko unki nani yaad dila denge. Lord, this is the statement of one of the accused. Lord, why I am saying this? Because a narrative is built that some intellectuals who merely protested, they exercised their fundamental right of protest. They are in jail since 5 years. And we will also show the delay is on whose behalf. Who is at the delay is attributable to whom? Who is responsible for the delay? The accused is responsible for the delay. We are ready, my lord, to complete the trial within 6 months. The moment, my lord, they cooperate. For the purpose of opposing charges being framed, each accused argued for 4 to 5 days. In some of the cases, the arguments went on for months for opposing framing of the charges. Lord, this has become a pattern, my lord, after your lordship's evolution of the bail law, that after 1 or 2 years, bail should be granted. Lord, now in all cases where on facts it is difficult to defend and pray for bail or persuade the court to release him on bail, the mechanism is delay the trial and say that there is a delay in trial. I will not go into the merits. Please do not go into the merits. Otherwise, you will be shocked to know, merely based upon the number of years of incarceration, give me the bail. Look, this is the position. Look, there was a systematic WhatsApp group which we have recovered from them.
All
Lord, one of the photographs which was shown by one of my learned friends was not photograph taken by us. It was photograph recovered from one of the mobile phone which we recovered. Photograph where they are sitting together for the purpose of creating a conspiracy, and the WhatsApp chats show how the property is to be damaged, how the money is to be collected. Therefore, my lord, I use the expression that it was systematic and synchronized attempt to divide the society on communal lines and divide the nation. It was not, and it is not, my lord, a case of a communal riot per se. My lord, since they have not said anything on merits, my lord, we will have to show everything. Now, what is the seriousness of the offense?
yes.
And we will, in that process, my learned senior friend would, my lord, demolish that narrative which is being, my lord, which is going on outside the court, that something very, very serious is going on with some young people. Well, this is all, my lord, I wanted, my lord, your lordships to be flagged at the outset, my lord. My learned senior would, my lord, assist your lord.
But essentially, there are three parts to the case of the accused. One is parity, second is delay, and third is without merits. Though they have not touched the merits, the third is merits. Let me first demolish the case on parity, Manoj. But they are relying on a judgment of co-accused. Out of which two were ladies, Natasha Narwal, the High Court
Who are they?
is 15,621.
Who are they?
Natasha Narwal, Devangna Kalita, and Asif Iqbal Tana.
Asif Iqbal.
Tana.
Who is the other one? Natasha, Asif,
And Devangna Kalita. Have you got a note? I'll hand over the note, Manoj. I'll get the note.
all right.
Manoj, Natasha Narwal's order is at page 334, annexure P5. No, I'm sorry. It is at page 294. 297. Devangna is at 408 in the petition of Kulfi Shah. The first one, when I said page 334, it is the matter of Sharjeel.
This Natasha is at which page?
Natasha is at page 297 to 407 in annexure P12 of Sharjeel Imam's petition. Devangna Kalita order is, all three orders are of 15,621. It is at annexure P6 of Kulfi Shah, pages 408 to 522. It is also annexed in the petition of Sharjeel Imam, annexure P13 at pages 299 to 447. The third judgment of the High Court, which is again dated 15/6/21, is of Asif Iqbal Tanha, which is annexure P7 of Kulfi Shah, pages 523 to 680.
526 to?
523 to 680. And annexure P14 of Sharjeel Imam, pages 476 to 575. The order granting bail was challenged before this honorable court. Although there were three, but they were challenged, my lord. Initially, this honorable court, your lordship, passed an interim order of 18/6/21, which is at annexure P8 of Kulfi Shah, page 681 and 682.
It was stayed.
Yes. No, it was said it is not to be treated as precedent and may not be relied upon by any of the parties in any proceedings. So categoric restraint. 680. Kindly have a look at page 682. My lords are having 682 of
Yes.
Kulfi Shah. The second last paragraph of the order, my lords have got it.
In the meantime, the improved judgment
shall not be treated as a precedent and may not be relied upon by any of the parties in any of the proceedings. Then, my lord, the final order was passed on 2nd of May 23. That, my lords, will find at page 769 of Kulfi Shah. The bail orders were not supposed to be used for the purpose of treating it as a precedent or for the purpose of the co-accused relying on it. That is clear, my lords. If my lords turn to page 770, my lords. First paragraph. The impugned order, my lord, may I read? My lords have got it. The impugned order is an extremely elaborate order of bail interpreting various provisions of the UAPA Act. Because various provisions were interpreted and they said it will not apply, and my lord, the High Court had done that. In our view, the only issue which is required to be examined in such matters is whether, in the factual scenario on an accused is entitled to bail or not. It is this argument which persuaded us while issuing notice on 18/6/21 to observe that the new judgment cannot be treated as a precedent and may not be relied upon by any of the parties in any of the proceedings. The idea was to protect the state against the use of the judgment on enunciation of the law or interpretation of the provisions of the UAPA Act in a bail matter. Respondents have been bailed now for at least 2 years. Therefore, my lords, the law which was enunciated was not approved by this honorable court. Then what was the law? The law was regarding
The next
interpretation.
para, the applicant is a co-accused.
Yes,
Please read the next para.
yes, my lord.
If the co-accused is entitled to a plea on parity,
Yes,
that is for him to make the court to
yes,
consider.
yes, I'm.
We want to make it clear that a cost of repetition. The purpose of this interim order
Again,
1986 for the
entitled
legal
to a
position
favor.
regarding
That is for him to make and the court to consider.
should not be
We
utilized
want
in
to make it
proceeding
clear
either.
at the cost of representation that the purpose of the interim order dated so and so was that the expounded legal position regarding.
That means on facts he can show it.
Yes, but on law, those accused were enlarged because of certain interpretations of the UAPA Act. I'll show from the order of the Delhi High Court, where they said UAPA applies in certain contingencies, doesn't apply in certain contingencies. That was not approved by this honorable court. Now, when my lords, your lordships use the word not to be treated as a precedent, my lords may kindly have a look. Again, my lord, your lordships have said your lordships have not gone into the legal position regarding statutory interpretation one way or the other. The interim order was made final, that's it. Now kindly have a look at 2002 8 SCC 158. You got a compilation. Para 9. State of Punjab versus Rajesh Sayal. Hello. Give me only one. Hello, return two sets. Same here. दे दो वापस.
So is there a compilation?
I'll give it to you. Yes, sir. My lords may turn to my lords. It is the second compilation, my lord, which starts at page 17. Kindly have a look at para 9. Para 9 at running page 20. Before concluding, we would like to observe with respect that by directing
You're reading para 9.
para 9 at running page 20 of the compilation. The pages are at the right hand side top corner.
Correct.
My lords have got it?
Yes.
Before concluding, we would like to observe with respect that by directing that the order which was passed in V.K. Sharma's case should not be treated as a precedent implies that the said order is otherwise not in accordance with law and therefore should not be regarded as precedent. Therefore, Lordship said, when your Lordship say that it is not to be treated as precedent, that is, it is not in conformity with law, therefore it can't be relied. Therefore, a judgment of the Delhi High Court which is not in conformity with law, as directed by this honorable court.
I think that would be with reference to position of law.
Position of,
Not of
but that is
position
because
of
of
facts.
position. Yes, but if they were granted bail not because of facts, but because of position of law. Therefore, I'll take my lord to the Delhi High Court stating why the bail was granted. The Delhi High Court precisely said that the rigors of 43D5, which is twin conditions, akin to section 37 of the NDPS Act or 45 of the PMLA, will not apply because of the interpretation of law. Therefore, it is not a simple interpretation of law. The effect of the interpretation is that the rigors of law, the rigorous conditions of 43D5 were excluded. Kindly for a moment have a look at section 43D5, my lords. UAPA.
Act is UAPA.
UAPA.
UAPA Act. UAPA. Act for unlawful prevention.
Getting it from my.
I can hand over my copy. Because the interpretation of law goes to the root of the matter. Now kindly have a look at section 43D, subsection 5. 43, capital D, subsection 5. Not which, my lords have got it? Not, there it no. Notwithstanding anything contained in the code, no person accused of an offence punishable under chapters 4 and 6 of this Act shall, if in custody, be released on bail or on his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused shall not be released on bail or on his own bond if the court, on perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. So if the accusation is prima facie true, then you can't grant bail. To get over this embargo, the High Court said 43D5 is not applicable by interpreting the provisions of law. Supreme Court said that interpretation is bad. If that interpretation is bad, the rigors would stand. If the rigors stood there, those people would not have been granted bail. Cancellation of bail, my lord, stands on a different footing than grant of bail. My lords are aware. The lordships have held in large number of judgments that if we were sitting in and hearing bail applications, we might not have granted bail. But since we are sitting in cancellation of bail, the jurisdiction is different. We have limited power, therefore the bail was not interfered with. But the court would not have granted bail had the interpretation of 43D5 been properly made by the High Court. Now kindly have a look, my lord, at two judgments which say that hearing a bail application, the cancellation of bail stand on two different footings. One is 1978 2 SCC 411. It is there in that compilation, my lords. Sanjay Gandhi's case. Page 240, my lords. Serial number 50. Kindly come to para 13. Starts at page 247. Para 13 at the bottom of page 230. Bail once granted to be cancelled, the considerations are different. Same compilation. Page 247. Rejection of a bail. My lords, you got it?
Yes.
Para 13 at page 247, right hand side top. Bottom of the page, para 13. rejection of bail when bail is applied for is one thing. Cancellation of bail already granted is quite another. It is easier to reject a bail application in a non-bail than to cancel a bail granted in such a case. Cancellation of bail necessarily involves the review of the decision already made and can be by and large be permitted if only if by reason of supervening circumstances it would be no longer conducive to a fair trial to allow the accused to retain his freedom during the trial. Similar is the judgment, my lord, in Daulat Ram, 1995, 1 SCC 349. It's not there? Not there in the compile, but I've got it separately. Kindly have a look at para 4. Rejection of bail in a non-bailable case at the initial stage and the cancellation of bail so granted have to be considered and dealt with on different bases. Very cogent and overwhelming circumstances.
Which paragraph you are reading?
For an order directing para 4. I'm reading para 4. I'm sorry.
All right.
Rejection of bail in a non-bailable case at the initial stage and cancellation of bail so granted have to be considered and dealt with on different bases. Very cogent and overwhelming circumstances are necessary for an order directing the cancellation of bail already granted. Generally speaking, the grounds for cancellation of bail broadly illustrative not are interference or attempt to interfere with due course of justice, administration of justice, evasion, or attempt to evade the due course of justice or abuse of the concession granted to an accused in any manner. Satisfaction of the court on basis of material placed on record.
Now, why are you putting up this proposition, Mr. Raju? For what purpose?
I'm saying that when this honorable court did not cancel the bail, the parameters of deciding a cancellation of bail application,
No, that is well known. No, why that situation has not arisen?
because in the case of parity, when the judgment
Parity is something
parity
different
lordship-
and cancellation is different.
cancellation, but that judgment on which they're relying on their contention was High Court granted bail, Supreme Court did not cancel. To meet with that contention, I'm saying
No,
cancellation principles are
that may
different.
not be right thing, but for the proposition, what you are saying that it was not to be treated as a precedent, to that extent, you may be correct.
Yes.
But on the issue of facts, if the facts unfolded on
Like-
same set of FIR,
My lords are right. Therefore, this is an additional submission to their argument that the SLPs were not entertained, though there was enunciation not to be treated as a precedent, but they were ultimately.
that is why the bail granted was not cancelled.
Therefore, for that proposition, I'm relying on that. Now, my lords may kindly have a look at the High Court judgment. Sharjeel Imam's petition. 534. And the interpretation of the High Court, which was flawed, my lord. Kindly have a look at Sharjeel Imam's petition, page 534.
I-34 in which case?
In Sharjeel Imam's case.
Can you please tell which item?
Sharjeel Imam is item number
1.1.
1.1.
All right.
Volume 1, 2.
It is in the, maybe volume, I thought it's in volume 1. Volume 1 or volume 2?
Which paragraph?
Paragraph 58 onwards.
58.
Yes.
That is the judgment.
It is the judgment of Asif Iqbal Tana.
I think, brother, you are not.
This is at page 476.
No, not that. He is reading it.
The judgment in Asif Iqbal.
It is Asif Iqbal. My lords will kindly have a look at it.
No, you are reading that paragraph 58 in our opinion.
It is judgment of 15 June 21, which was challenged before this Honorable High Court. 15. Kindly
15.
note at page 476. It is judgment of 15 June 21.
Paragraph 58.
Paragraph 58. That is the very judgment of the High Court where your lordships have said
Granting
not to be treated as
bail to Asif Iqbal.
Yes,
The paragraph starts, in our opinion, the intent and purport.
yes, yes, my lord. In our opinion, the intent and purport of Parliament in enacting the UAPA and more specifically in amending it in 2004 and 2008 to bring terrorist activity within its scope was and could only have been to deal with matters of profound impact on the defense of India. So they said UAPA is confined only to defense of India, which your lordship said no on principle. They said it doesn't lay down the correct law. Nothing more and nothing less. Absent this, UAPA could not have been enacted by the Parliament since the only entries in list 1 of the 7 schedules of the Constitution that would bring the statute within the legislative competence of Parliament are entry 1, read with entry 93, relating to defence of India and offences with respect to the defence of India. It was neither the intent nor the purport of enacting the UAPA that other offences of usual and ordinary kind, however grave, egregious, or heinous in their nature and extent, should also be covered by the UAPA. Since such conventional matters should have fallen within entry 1 of list 2 state lists or entry 1 of list 3 concurrent list of 7 schedule, even as a concurrent list, Parliament has the power. In order to lean in favor of constitutionality of the provisions of section 15, 17, 18 of UAPA, we must be taken that Parliament acted within the realm of its legislative competence and that UAPA came to be enacted as amended in 2004 and 2008 to address issues relating to defense of India. Because they said UAPA is restricted only to defense of India. In the above view, the scope and ambit of UAPA in particular sections 15, 17 thereof are based on allegations made in the subject charge sheet against the appellant as highlighted before us on behalf of the state, which we find is the following. Then, my lord, the activities are highlighted and referred to. Then kindly have a look, paragraph 62 at page 538. They said unless it pertains to defense of India, UAPA is not attractive. It is because of that their lordship felt that 43D5 is not attractive. And kindly now have a look at 62 minutes. Once we are of the opinion, as we are in the present case, that there are no reasonable grounds of believing that the accusation against the appellants are prima facie true, proviso to section 43D would not apply. And we must therefore fall back upon the general principles of grant or denial of bail to an accused person charged with certain offences. So the Delhi High Court said 43D5 doesn't apply because it is restricted only to defense of India. These acts do not pertain to defense of India. Therefore, the UAPA Act will not apply. If the UAPA Act does not apply, offences under Chapter 4 and 6 will not apply. If the offence under Chapter 4 and 6...
So they say prima facie true, is it?
Prima facie true is again wrong. It's a wrong thing.
Huh?
Can you have a look at section 43D5 again, madam? The word is not prima facie true. Prima facie, yes, madam. Accusation, grounds for believing that the accusation against such persons are prima facie true.
Huh.
That is 43D5, that is wording of section 43.
So if that is done, bail should not be granted. That is your contention.
That is
Here, what is the on facts? They said prima facie true.
prima facie, no, kindly have a look. Charged with certain, kindly again.
No reasonable grounds.
Yes, there are no reasonable grounds of believing the accusation against are prima facie true.
They said it,
No reasonable.
in other words, they said it is not prima facie true.
True. On what is the reasoning for this? that UAPA is not attracted, not on facts. UAPA is not attracted because it is not put into defense of India. UAPA is not attracted, therefore, no private.
No, it is arising out of the same FIR,
Same affair, same thing,
same offense.
same offense.
Then how do you distinguish?
Therefore, the distinguishing is this. It is not based on facts. It is based on a fact.
No, Mr. Raju, we are not on that. See, please go to page number 476.
Yes, my lord.
Paragraph 2. The appellant is presently in judicial custody, having been arrested on 19/5/2020 in FIR number 59 of 2020, dated so and so, registered under section 147, 148, 149,
Same affair.
120B of IPC.
And then, my lords, may see further, my lord. Under section 13, 16, 17, 18 of Unlawful Activities Prevention Act.
Where do you get that?
In the letter 477 at the bottom, my lord. After the IPC offences, after the
It may be noted that the offence.
477 and UAPA, my lords. Kindly have a look at last portion, section 13. My lords are having 477.
Yes.
Violation and rioting occurred in Northeast Delhi.
So section 13, 16, 17, 18 of Unlawful Activities Prevention Act 1967.
So if UAPA offences are
Were
there,
subsequently added to the subject FIR. At the time of his arrest, the FIR on 19/5, the appellant was already in judicial custody. Different case arising in FIR 298, registered and so on, so and so. 3 and 4 of PDPP Act, Jamia Nagar, New Delhi. In connection with the protest held in Delhi 2019 against Citizenships Amendment Act 2019 passed by Parliament and the exercise proposed to be undertaken by the central government for creating a national register of citizens, or short. It must be mentioned that in case FIR number so and so, appellant has since been admitted to regular bail by the Learned Sessions Court, Saket, New Delhi.
may I only point out two things, my lord. If a person is accused of an offence under UAPA, chapter 4 and 6, which they are, the court cannot grant bail unless the conditions of 43D5 are complied with. A 43D5 compliance can be
We want
on
to
facts.
know juxtapositioning the offences alleged against Asif Iqbal vis-a-vis these 3 persons, these 5 persons.
Yes. Now, what I'm saying is this, my lord. When the High Court said section 43D5 doesn't apply, the High Court did not say on facts. The High Court said interpreting the provisions of the UAPA and said UAPA is restricted only to defense of India. If it is restricted to defense of India, these acts committed by the accused do not fall in the realm of defense of a violation of anything to do with defense of India. Therefore, 43D5 doesn't apply. The High Court did not say, look at Acts 1, 2, 3, 4, and 5. Irrespective of whether it is Defense of India Act or not, committed on offence under UAPA, therefore they are entitled to bail or not entitled to the rigors of the condition 43D5. The High Court has not said that. High Court went on a statutory interpretation and came to the conclusion why 43D5 is not applicable, not on facts, but on law. Therefore, Supreme Court said we don't agree. Again, I make at the cost of repetition at page 770. Supreme Court said on law, this High Court was wrong. Therefore, 43D5 applied. If 43D5 applied, the High Court could not have granted bail. 770 of Gulfishar's judgment. Again, my lord.
770 of
Gulfishar. 770.
going back to serial number 1.
Yes. First paragraph. The impugned order is an extremely, my lords have got it? I'm sorry.
Yes. Elaborate order of bail interpreted.
Elaborate order of bail, my lord Justice Ranjari has got it. The impugned order is an extremely elaborate order of bail interpreting various provisions of the UAPA Act. That is the High Court. In our view, the only issue which is required to be examined in such matters is whether in the factual scenario an accused is entitled to bail or not. The High Court did not do that. The High Court went on statutory provisions that said UAPA is not attracted. So the Lordship said that should not have been done. You should have examined the factual scenario. It is this argument which persuaded us while issuing notice on 18/6/21 to observe that the impugned judgment cannot be treated as a precedent and may not be relied upon by any of the parties in any other proceedings. The idea was to protect the state against the use of the judgment on enunciation of law. What is the law? UAPA applies only to defense of India. That law was wrong. And because of that, you granted him bail, saying that it is not for defense of India. It is only, since it is not for defense of India, 43D5 doesn't apply. The idea was to protect the state against use of judgment on enunciation of law qua interpretation of the provisions of UAPA Act. Then, my lords, may kindly turn to page 771, second paragraph. The applicant is a co-accused. If co-accused is entitled to prior parity, that is for him to make the court to consider. We want to make it clear at the cost of repetition that the purpose of the interim order dated so and so that the expounded legal position regarding statutory interpretation in a bail matter should not be utilized in proceedings either of a co-accused or other person or any other matter. Therefore, this interpretation saying that co-accused should make out his case on facts is because the High Court did not decide on facts whether UAPA is attracted or not. Therefore, this second observation. Then, my lord, the second mistake that the High Court committed was this. Once you hold that 43D5 is not applicable, you exercise powers under 437 or you exercise powers under 459 of the court. The High Court, in the order which was challenged, was faced with a situation as now since the High Court has held that 43D5 is not applicable, so ordinary criminal law will apply. Which is that ordinary criminal law? The High Court was facing that problem, whether it is 437 or it is 439. If it is 437, then if it is imprisonment for life, you can't bail. Ordinarily, you can't. That's the distinction between 437 and 439. Kindly have a look at 437 and 439 of the CRPC. My lord, sir, having 437.
Yes.
When any person accused of or suspected of commission any non-bailable offence is arrested or detained without warrant by an officer in charge of police station, or appears or is brought before a court other than the High Court or Court of Sessions, he may be released on bail. But such person shall not be released if there appear reasonable grounds for believing that he has been guilty of an offence punishable with death or imprisonment. So if the powers are under 437, you can't release a person if he is prima facie guilty of an offence punishable with death or imprisonment for life. That restriction is missing in 439. My lords may now have a look at 439.
Read proviso.
Yes, that is for aged persons, women. We are not concerned. Yes.
Right.
Now kindly have a look. Provided that the court may direct any person referred to clause is released on bail if such person is under the age of 16 or woman over 6 or infant.
So if this embargo is there, even according to it would not apply.
That embargo is not there under 43D5.
All right.
That embargo
437 is applied.
My first contention is 43D5 applies. The second alternative submission is
if it is held to be not applicable,
437 would apply, not 439, which the High Court said applies.
437 also, the proviso gives the benefit to the first petitioner, Gulfi Shah.
That is how 437 has been interpreted. I'll come to it later. I'll come to it. It is not as a matter of course in certain grave situations.
You said 437.
Yes,
437 there is a clear embargo under subclass 1 of subsection 1.
Yes.
So now that subclass 1 of subsection 1 is diluted by the proviso.
But proviso doesn't apply in all cases. Proviso doesn't apply. How the proviso is interpreted, I'll come to that. But I am on a technical ground The High Court says 437 will not apply. I am exercising powers under 439. Where there is no proviso, there is no restriction. 439, there is no restriction. My lords are aware. High Court or the Court of Sessions, there is no such restriction. Now the High Court said, after saying that 43D5 is not applicable, now I will exercise powers under 439, not 437. That, my lords, will find at page 541 at para 70.
540
541, the same judgment, Sharjeel Imam, my lord,
is 1 or 1.1?
1.1. Same para 62 I read, now para 70.
Page 5?
541. Digital is 591. 591.
Paragraph?
And it is
Paragraph?
paragraph 70.
In this behalf, the
In
submission.
this behalf, submission made on behalf of the state, which we must address, is that the High Court, while deciding appeal under Section 21 of the NI Act, must consider the grant of denial of bail only within the parameters of 437 and not under 439 CRPC. Since the High Court is seized of an appeal arising from the special court as acted under 437, since in dealing with such a case under the UAPA, the special court is not a court of sessions, although the learned ASG contends that this is the principle laid down by the Supreme Court in Kartar Singh's case. We are unable to find any precept to that effect laid down in Kartar Singh's case. Moreover, to say that while considering a bail plea, even an appeal under Section 21 of the NI Act, the High Court would be constrained by the restrictive power of bail under 437, in our view, does violence both to the express wording of 437 and also to the wider powers of the High Court with regard to bail under Section 459. It requires to be noticed that section, there is a typo error, it should be 430. That Section 437 in so many words applies to a court other than the High Court or Court of Session. These words in Section 437 CRPC cannot be deemed to have been amended by any provisions of the National Investigation Act or the UAPA. Moreover, it does not appeal to a sense of reason. Now, my lords, dealing with the bail in an appeal under Section 21 of the NI Act, the High Court be bereft of its own powers under 439 CRPC or absent even those powers would be unable to act ex debitu justitiae in exercise of the inherent powers under Section 482 CRPC. In our view, therefore, regardless of the fact that the present case arises as an appeal under Section 21 of the NI Act, since the additional constraints under 43D5 of the UAPA Act do not apply, this court would be entitled to consider the matter of bail on the touchstone of the provisions of 439. So the High Court said 439 applies, not 437. It is contrary to my lord's judgment. Kindly have a look at the first judgment in my compilation. Relevant is page 15.
Hmm.
27.2.
27.2.
It is an appeal, my lord. It is an appeal. So when you are deciding an appeal, you have the same powers as the original court. The original court doesn't have the powers under 439. It is not an independent proceeding so as to attract 439. And secondly, I'll also got it para 22.2 at page 15 of my compilation. Secondly, as far as prayer B of the petition for clarification is concerned, it is made clear inasmuch as the appellant is being prosecuted for offence under the MOCA Act as well as Unlawful Activities Prevention Act 19. Such offences are triable by the special court, and therefore application for bail matters have to be made before the special court under the NI Act and shall not lie before the High Court either under 439 or 484. Application of bail filed by the appellant in the present case is not meant to be before the High Court. The High Court doesn't have the powers under 439. Well, to get over having held that 43D5 doesn't apply, therefore rigors do not apply. The High Court, in order to get over the rigors of 437, which says life imprisonment, you can't grant bail, resorted to 439, which is contrary to my lord's this honorable court judgment that 439 powers the High Court doesn't have in a matter of UAPA. The second mistake that the High Court committed, and therefore granted bail. And rightly, your lordships have said in the SLP that is not to be treated as a precedent. If it was not on merit, the matter was decided. Yes, ma'am. Now I will Then, my lord, there are two things. If a somebody is granted by wrong interpretation of precedent or judgment or law, there is nothing like negative equality. Two judgments on this point. That is, one is Tarun Kumar versus Assistant Director of Enforcement, para 18. That is a compilation. Page 22 of my compilation. So those three persons were wrongly granted bail by wrong interpretation of law. So it can't be extended to these persons. Yes. Para 18 at page 39. Bottom of page 39.
Yes.
So I have demonstrated that those three persons were wrongly granted bail by misinterpretation of law, both on 43D5, both on the interpretation of UAPA, which has been not accepted by this honorable court, and also on the provisions of CRPC applicable to High Court. Now, para 18 at page 39, my lords. It is axiomatic, my lords have got it?
Yes, yes.
The axiomatic that the principle of parity based on guarantee of positive equality before law enshrined in Article 14 of the Constitution. However, if any illegality or irregularity has been committed in favor of an individual or a group of individuals, or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of higher or superior court for repeating or multiplying the same irregularity or illegality, or for passing a wrong order. Article 14 is not meant to perpetuate the illegality or irregularity. If there has been a benefit or advantage conferred on one or a set of people by an authority or by a court without legal basis or justification, other persons could not claim as a matter of right the benefit of on the basis of such a wrong decision. Then when Arvind Kejriwal's judgment, which is 2025 2S248, para 248, para 87, I'm sorry, para 87. Is at page 107 of my compilation.
Thesis. Yes. Paragraph. Which para?
Para 87 at running page 107.
Yes. We are conscious.
We are conscious, not this Anjarya.
It is a, yes, yes.
We are conscious that the principle of parity or equality enshrined under Article 14 of the Constitution cannot be invoked for repeating or multiplying irregularity or illegality. If any advantage or benefit has been wrongly given, another person cannot claim the same advantage as a matter of right on account of the error or mistake. However, this principle may not apply where two or more courses are available to the authority. Doctrine of need and necessity, that is on fact. That is on facts. There are other judgments which say the cancellation of bail stands on different footing. I need not multiply the authority. There's one more aspect as far as delay is concerned, which is peculiar to Manoj, the Umar Khalid.
On the issue of delay.
Question of delay or question of parity. And it will apply in other merits also, Manoj. The principle is this, Manoj. you can file successive bail application. No quarrel about it. But you can't file successive bail applications on the same facts. You can file it only if there are changed circumstances. Court will not entertain a successive bail application if it is not based on change in material circumstances. Material circumstances may be those circumstances which were argued, even if not argued, but in existence at the time when the matter was decided. There is no question of entertaining the bail application on that ground. Now let us examine, my lord, the question of parity, whether it was in existence at the time when Umar Khalid's application was decided. I'll give a few dates, my lord. High Court granted bail. 15/6/21 is the date when the High Court granted bail, on which they are relying for the purpose of
It
parity.
is Asif Iqbal.
Tana Asif Iqbal, Devangna Kalita, Natasha, and all those 15/6/21. 15/6/21 is the date of the order on which parity is claimed. Original order of the High Court is 15/6/21. 18/6/21 is the interim order where your lordship said not to be treated as a precedent.
Oh,
And when the final order was passed on 2/5/23. But before that, on 18/12/22, the High Court rejected his bail application. So when High Court rejected his bail application on 18/12/22, it was after 15/6/21. He could have
what is that?
Step-
18/6?
18/12/22. High Court rejected his bail application.
18/12, this court said it should not be treated as precedent, is it?
He did not. He must have argued that other co-accused have been granted bail. Give me the
You said 15/6/21.
He could have argued, or he must have argued, or could have argued. He did not argue. So it was 6 months earlier.
All right.
Sorry, I'm sorry to interrupt.
It is 18/10.
It's 18/10.
18/10. There's a mistake. But anyway, it is after 15/6. Doesn't make a difference. So when you went to the High Court, when the High Court rejected bail, you are aware of the fact that co-accused have been granted bail. You must have argued, or you must have deemed to have argued that point. Then, my lords, may kindly have a look. The final order of the Supreme Court is dated 2/5/23. So 15 June order taken to the Supreme Court. Supreme Court's final order comes on 2/5/23. Now his bail application is rejected, withdrawn on 14/2/24. Because this Honorable Court was not inclined, you withdrew it on 14/2/24. After the order of this Honorable Court on 2/5/23. So parity was there. You would have argued, or you could have argued. There's no change in material circumstances after that. So as far as Umar Khalid is concerned, there is no change in material circumstance warranting a fresh look at the question of parity, because parity was already in existence when his earlier bail application was decided. Therefore, Umar Khalid's case on parity has to be rejected, not only on the grounds which I have earlier urged, but also on an additional ground that does not constitute a change in circumstance. A change in circumstance, I thought that I would have dealt with at the time of merits, but since this issue has arisen, can I have a look, cite 2 or 3 judgments on this point? Where is it? Kindly have a look at Kalyan Chandra Sarkar, 2005, 2 SCC 42, which is a page. Which is starts at page 129 of my compartment.
para 20.
There are 18, my lords. 18.
You are referring to Kalyan Chandrasekhar Sarkar.
Yes,
Huh?
yes. There are 19, 18 and 18 and
In your compilation, you have said only para 20.
I'm so sorry, my mistake.
Okay. You want us to look into paragraph 18,
18, yes.
19 and 20 also?
Yes.
All.
Come to the last 4 lines of page para 18, my lords. The sentence starts, last 6 the sentence starts like this. In that process, a person whose application for enlargement on bail is once rejected or not, is once rejected is not precluded from filing a subsequent application for grant of bail if there is a change in the fact situation. In such cases, if the circumstance then prevailing requires that such person be released on bail in spite of his earlier application being rejected, the courts can do so. So there has to be change in circumstance. There is no change in circumstance as far as parity is concerned, as far as Umar Khalid is concerned. Then, para 19. The principles of res judicata and such analogous principles, although are not applicable in criminal proceedings, still the courts are bound by the doctrine of judicial discipline having regard to the hierarchical system prevailing in our country. The findings of a higher court or a coordinate bench must receive serious consideration at the hands of the court entertaining a bail application at a later stage, when the same has been rejected earlier. In such an event, the courts must give due weight to the grounds which weighed with the former or higher court in rejecting the bail application. Ordinary issues which have been canvassed earlier would not be permitted to be re-agitated on the same grounds, as the same would lead to a speculation of uncertainty in the administration of justice and merely forum hunting. Then para 20, the decisions given by a superior forum undoubtedly are binding on the subordinate fora on the same issues, even in bail matters, unless, of course, there is a material change in fact situation calling for a different view being taken. Therefore, even though there is room for filing a subsequent bail application in cases where earlier bail applications have been rejected, the same can be done if there is a change in the fact situation or the law which requires the earlier view being interfered with, or where the earlier finding has become obsolete. This is the limited area in which an accused who has been denied bail earlier can move a subsequent application. So in case of Umar Khalid, there is no scope for a subsequent application on the ground of parity because the parity fact was available at the earlier point of time. Page 145 of my compilation.
Page number?
Page number 164. There, subsequent bail application was filed on the ground that there is delay in trial. But delay was caused because the stay he has obtained. In our case, delay has been caused because of them. My lord, I'll demonstrate when I deal with delay.
Is on the issue of delay.
This is not on, this is the issue of change in circumstance. Even delay can't be a change. I can rely on both times when I argue delay also. There are 71, my lords have got it.
1 second.
This judgment will apply not only at here, but also when I argue delay.
Page number?
Page number 164.
Yes.
As far as the appeal preferred by Jamiruddin Ansari is concerned, the trial has not progressed on account of stay orders passed by this court on appeals filed by the state of Maharashtra against the conviction, against the decision of the full bench on reference made on conflicting views expressed by different benches of the High Court with regard to interpretation of Section 9 and 23 of the Makoka, except for the fact that the appellant has undergone a further period in custody. There is really no change in circumstances under which his initial bail application was rejected. We therefore see no reason to entertain the appeal filed by him in the same dismissed. So delay trial is not a change in circumstances. That is what your lordships have had. Then kindly have a look at S.A. Raja's case, 2005 8 SCC 380. It is at page 169, the relevant para 9. Starts at
Page next.
Judgment starts at 166, relevant para is 169, para 9. May I read, my lord?
Yes.
160. When a learned single judge of the same court has denied bail to the respondent for certain reasons, and that order was unsuccessfully challenged before the appellate forum.
No, I don't think, Mr. Raju, you don't require any
Very well.
elaborating
I'll
on this
leave it.
issue
I'll leave it
that
at that. Now let me come to
proposition that until and unless there is a change circumstances, no fresh application is
no change.
that we have repeatedly held.
Then now this parity issue is over. Now I'll come to delay.
Oh.
I'm relying on a judgment of Taslim Ahmed versus Delhi's NCT of Delhi, passed by the Delhi High Court, which is at pages 180 to 216 of the counter. That judgment has not been challenged, my lords.
Which one?
It is Taslim Ahmed versus State of NCT, which is at page 17 of my counter, my lords.
Counter in which case?
Counter is in which case? It's a common counter.
No, we don't know in which case you have filed.
I filed it in all. It's a common counter for all.
Common counter affidavit on behalf of respondent.
I don't know where it is.
Title.
Yes.
On title.
Same.
Which page?
Same. Count page 1.
Huh?
It starts.
Page
It is annexure R3
R3.
for page 180.
Which
The relevant portion is extracted in my counter. Page 17 of my counter.
what do you want us to look at? Page 17 or page 180?
Page 17 onwards.
Oh.
Actually, page 19 minutes.
Which para? Para 22?
Yes, para 22. This is the same case, Manu. Same case. Co-accused. The judgment of the Delhi High Court has not been challenged.
So for one, you are relying upon the Delhi High Court judgment which refuses the bail. And for the one which is granted the bail, you are saying don't took it.
I am saying that as far as delay is concerned, this is directly on the point of delay.
All right.
Otherwise, I'll have to show the record of the case. It will be very time consuming. That's why I'm saying.
All right.
Otherwise, I can point out from the record. May I read para 22 onwards? Without
Yes.
this about it is most useful submitted that the Honorable Delhi High Court by the separate judgment of even date being Taslim Ahmed versus State of Delhi. In the same FIR, were dismissing the appeal of a prior accused and after examining the record has adds in unequivocal terms held that the delay in the trial is solely attributable to the accused. It is submitted though the said judgment has direct bearing on the instant case. However, none of the petitions except Mohammed Salim Khan has placed the same on record, with the scathing observations made in the same judgment. It has been a bona fide relief of the respondent that an attempt has been made by the petitioner to suppress the same to the Honorable Court. However, dehouse the above, the opponent is placing the said judgment on record of this Honorable Court, and for ready reference of this Court, the crucial findings of the same are quoted here in para 17 of the judgment. The only question which remains for adjudication is whether bail under Section 43D5 of the UAPA can be granted to the appellant solely on the ground of delay in the facts of the present case. To ascertain the correct feature, it is pertinent to sum up the proceedings of the trial court and the same are tabulated as under. The first column is date of the order, second is summary. The first candidate will look at 5/8/23. Compliance under 207 of the CRPC for all the accused persons was completed. Matter was listed for arguments on charge on 11/9/23 onwards for a day-to-day proceeding. Learned SPP submitted that he shall commence his arguments on 11/9/23. 11/9/23, but this is what accused persons, namely Devangna Kalita, Natasha, Asif Tana, objected to commencement of arguments on charges as the investigation is still ongoing. These are the persons who are released on bail. Learned SPP state that he is ready to begin the arguments and objections were raised that despite giving considerable period of time for starting the arguments on charge, no agenda application was moved on the time. He stated that the accused persons will later claim bail on the ground of delay in trial. Taslim has submitted that he wants arguments on charge to begin. Then 18/9/23, accused person namely Miran Haider, Akhtar Khan, Khalid Saifi, Faizan Khan, Isat Jahan, Sharjeel Imam, Sulaiman Jahan, Salim Malik, Rajpuna Shifur Rahman, Sadab Ahmed, and Gulsiba Ahmed have sought for deferment of arguments on point of charge as investigation is not yet completed. Why charges can be framed, there can be additional evidence that can come. On the material before the court, the charges have to be framed, not on material that will come in further investigation. But they wanted to delay the trial, therefore they said in further investigation going on, if further investigation something comes, they can always move for modification of the charge. On the other hand, accused persons, namely Salim Khan, Taslim Ahmed, and Tahir Hussain submit that they want arguments on charge to begin. Then 6/1/24 to 8/8/24, accused who got bail were not permitting the arguments on charge to commence. That was the facade. The real thing is so that the others may get bail on ground of delay. There is nothing to indicate that during this period the appellant made any specific argument to jump the queue and advance arguments on charge. Adjournment is sought to address the arguments in rebuttal. Then 29/24, accused persons collectively submitted to the learned trial court that they shall arrive at a consensus on who will start the arguments on point of charge and stated that schedule to that effect will be submitted to the learned trial court for convenience purposes. Then 4/10/24, accused person namely Tahir Hussain, Asif Tana, Umar Khalid, Sharjeel Imam, Jahan sought for adjournment, citing difficulties in commencing the arguments on charge. Accused learned trial court has recorded in its distress in the said matter as accused persons are delaying the proceeding despite reaching a consensus on addressing the arguments in a particular sequence, and the consent has been taken to argue the matter on a day-to-day basis. However, the accused persons, including the appellant, were not ready to start their arguments on charge. Then 20th of November 24 to 7th of February 25. Adjournment sought by the accused person, no attempt is made by the appellants to commence arguments. Then 2nd of February 25, objections of the learned SPP is recorded where he submits that despite directions of day-to-day hearing, the accused persons are not coming forward to address the arguments on charge. He also stated nobody is ready to address the arguments till date, despite a consensual schedule having been made among the accused persons. Then 4/4/25, Taslim Ahmed commenced and completed his arguments on charge. 8/4/25 to 2/7/25. A judgment sought by other accused persons citing certain difficulties in arguing the matter on charge. Then para 20. Upon perusal of the aforesaid table, it is observed that by order dated 5/8/23, arguments on charge are being heard from 11/9/23 onwards. On 11/9/23 and 18/9/23, several co-accused objected to the arguments on charge with the ongoing investigation. Therefore, cannot be said that the state is delaying hearing on the charge. Then para 21. Material on record indicates the reluctance on part of the accused, including the appellant, to advance the arguments on charge. So on 20th of September 24, a consensus was reached by the accused person to streamline the proceedings by submitting a schedule as to who will argue on charge sequentially. Despite the same, arguments on charge were not commenced by the appellant. The learned trial court recorded distress in the order dated 4/10/24, which reads as under. It is surprising that on the last date of hearing, the court specifically noted that the matter shall be heard on charge on day-to-day basis. And after considering the submission of the learned counsel for the accused person, that they will make consensus
yes.
among them.
Kapil Sibal wanted to go, so he was.
He's not likely to finish that.
All right, please.
If you want, I'll finish and continue tomorrow.
Huh?
If you want, I'll finish and continue tomorrow.
No. Today we'll be raising at 3:45. We'll be raising till 3:45. You can complete it.
Whatever is possible. It is surprising that on last date of hearing, the court specifically noted that the matter shall be heard on charge on day-to-day basis, and after considering the submission of the counsel for the accused person, that they will make consensus among themselves for addressing arguments on a particular sequence, and with their consent, only the matter was fixed today for arguments on charge. But still, none of the counsel is ready to address arguments. The court sees that more than sufficient time was given, but still, learned counsel for the accused persons are not ready today. The accused persons are warned that the matter should not be delayed further unnecessarily on their part, and any delay will be viewed by the court seriously. A bare perusal of the order sheets clearly indicate that the learned counsel for the accused have taken many adjournments during the course of arguments on charge. The order sheets show that the learned counsel for the accused were not ready to argue the matter on charge, thereby protracting the proceedings. The fact and order sheets reveal that the accused themselves have been responsible for delaying the trial at various points in time. The inordinate delay in trial, as alleged by the appellant here, is not due to inaction of the respondent agency or the trial court. In para 23, material on record shows that at no point of time the trial court has unnecessarily delayed the arguments on charge. In fact, to facilitate the proceedings properly and in a speedy manner, the learned trial court has ensured that the proceedings take place in a structured manner, wherein liberty was given to the accused person to come to a consensus as to who will argue the case sequentially. In light of the reasons, especially in view of peculiar factual case, appellant cannot be granted bail under Section 43D5 of the UAPA Act only on the ground of delay in trial, keeping in mind the judgment of Gurvinder Singh, as the same would have to include determination of prima facie case, which would involve an assessment of case on merits as well. The para 38. Material on record indicates that certain accused persons have got bail and some of the accused persons are in prison. Those accused persons who got bail are trying to delay the arguments on charge on the ground that the investigation is still pending. The arguments of charge are being delayed by the accused persons who are out on bail at the cost of those accused who are in prison. Despite orders from the court directing counsel for the accused person to decide among themselves as to how and in what order the arguments of charge will be advanced by the accused, there seems to be no consensus among them. Mr. Mahmood Pracha, learned counsel for the appellant, has tried to contend that the accused waited in queue patiently as it would not have been fair on his part to jump the queue and advance arguments on charge. However, that contention of the learned counsel for the appellant cannot be accepted, as the appellant did not advance argument despite request by the special court and has advanced arguments only on 4/4/25, which is during the pendency of the instant appeal. The court does not find any infirmity in the impugned order passed by the learned trial court rejecting bail application on the ground of delay. Undoubtedly, speedy trial is a concomitant and a facet of Article 21 of the Constitution of India. However, to ask...
Raju, we look into it because you have highlighted that portion with a tabular column and an arrow mark in red ink. In your counter, we look into it.
This is for all the accused, not specific. Now, my lord, even where co-accused para 26 onward for the High Court order, which says even after this order which I read, there has been delay on their part. That, my lords, will kindly have a look at para 26.
Of the impugned order?
This is our counter. Page 26 is the counter. What happened after the order which I read in the High Court? Para 26 of my counter. Para 26.
Para?
26 of my counter.
A bare reading of
Page
the order.
24 of the same counter.
It starts a bare reading of the order.
Bare reading of the order dated 1st of August 25 would demonstrate after the learned counsel to the accused Sadab Ahmed concluded the arguments on framing of charge. The trial court called upon the remaining accused to argue on the issue of framing of charge. However, remaining accused refused to argue on one ground or the other, forcing the learned trial court to defer the matter on 4th of August 25. In fact, the accused herein, while refusing to argue on fixed date, stated that they will let the court know at the earliest as to when he will start the argument on charge. This expressly demonstrates the conduct of the accused to delay and derail the trial proceeding. The relevant portion is reproduced here in the learned counsel for the accused Sadab Ahmed submitted that he has already concluded the arguments and will file written arguments and relevant judgments within 2 weeks. Ms. Arza Rahman, learned counsel for the accused Faizan, submitted that she will address the argument in the last. Manvinder Singh Shekhawat, learned counsel for the accused Devangda and Nasser submit that he has challenged some order of this court in the Honorable High Court of Delhi and therefore he will address the argument in the last. Counsel for the accused Isra Jan submits that the main accused has given the instruction that he will address the argument in the last as the case of his client. So everybody wants to address the last, nobody wants to address it. Despite the fact that schedule was framed, accused Miran submitted he has not spoken with his counsels, Sri Singh and Sri Farah Makbul, and he has no knowledge as to when his counsel will address argument. Accused Salim Malik submits that he has no instructions from his counsel, Sri Archit Krishna, regarding the argument. Sri Anirudh Ramnathan appeared for accused Salim Malik, appeared on the first call, but did not apprise the court as to when he will address the argument in charge. Ms. Anshala Verma, learned counsel accused Mohammad Salim Khan submits that the main counsel, Sri Gautam Khajanchi, has given instructions that the bail application of the accused pending before the Honorable High Court and arguments of charge will be addressed after this month. So even months, accused Atar Khan submits that he would not speak for his counsel Arjun Diwan and he will be able to apprise the court about arguments and charge only after speaking with his counsel in the next week. Accused Sharjeel Imam submits that he will speak to his counsel and apprise the court as soon as possible. Sharjeel further submits that he is the second last accused in the charge sheet and he would like to address the argument in the last. Accused Umar Khalid, the present in court, submits that he will speak to his counsel Pradeep Faiz and let the court know at the earliest when he will start the argument in charge. Learned SP submits that he has objection that till date only 8 accused have addressed argument in charge and remaining 10 accused persons are still to address argument, but they are not coming forward to address arguments and the matter is still getting unnecessarily delayed. Copy of the order is R4. Then, thereafter on 5/8/25, arguments on behalf of accused Natasha Narwal, Devang Nagar concluded with liberty to address further arguments subject to outcome of petition filed with the Honorable High Court. However, certain co-accused again sought for further time to address arguments, delaying the trial yet again. The relevant portion of the order is reproduced here and below. With Pradeep Faiz, counsel for the accused Umar Khalid submits that may I continue?
Yes. More.
Day after tomorrow, day after tomorrow. Tomorrow there is some problem.
Tomorrow?
There is some slight problem. Day after tomorrow, one date.
All right. Day after tomorrow.
Yes.
UAPA Act only section
43 D5.
13, 16, 17, 18 is invoked.
Yes. And
What is the minimum
for
punishment?
the bail.
Minimum punishment
Life,
for
life,
all?
life.
No, minimum.
5 to life, it says.
5 to life.
5 years?
Some it is 5 to life.
No, section 13 it is only 5.
Yes.
16, 17, 18 subject to correction, what you may say. I think it is minimum 5 years, which may extend up to life imprisonment.
But the Life is one of the punishment.
Hmm?
Life is one of the punishment. Minimum is 5 in other cases, not in a case like this. Well, later, I have not applied my mind on this. I'll address my lords on this aspect later.
All right.